Hi, and welcome to this edition of Criminal Justice Natters with me, Ed Johnston. On this show, we are joined by Charlotte Henry, who is a campaigner for JENGBA, and we will be discussing the law and sort of issues with the law concerning joint enterprise and how you might be convicted of an offence when you haven't necessarily committed it yourself. It's quite a complex area of law. It's rife for reform. And I hope you enjoy the show. Hi, Charlotte. Thanks for joining us this evening. How are you?
I'm good, thank you. How are you?
I'm very well, thank you. Thankfully, the sun's returned to the southwest of England, so that's good.
Yeah, same. The last 2 days have been nice.
Yes. Just for our viewers, I wondered if you could introduce yourself and just a little bit about what we're going to talk about this evening.
Yeah, so my name is Charlotte Henry. I am a JENGBA campaigner. That stands for Joint Enterprise Not Guilty by Association. I'm also the sister of someone convicted under the Joint Enterprise law.
Okay. So who are JENGBA and what is it that they're looking to do?
So JENGBA is a grassroots campaign. We were founded in 2010 by Gloria Morrison and Janet Cunliffe. And we're primarily run by family members of those who have been convicted under the Joint Enterprise law. We support over 1,000 people convicted, and most of which have been convicted for homicide offences, mostly murder.
Okay, and what, in its simplest form, what is joint enterprise?
So joint enterprise, I guess in its simplest form, there isn't really like a simplest form, but it's a colloquial phrase. It's not actually kind of like a legal terminology. And it is used to describe a situation where two or more people are convicted of the same offence. It's a kind of like it's a common law doctrine. So the boundaries that have developed through decisions through common law have restricted its application into three different contexts.
Okay, and what are those three contexts?
So the first one is joint principles. That's where two people go, or two or more people go to commit crime. And both are principles because they satisfy the actus reus of the offence and the mens rea of the offence. Actus reus being the conduct, the physical part of the offence, and the mens rea being the mental element. So an example would be two people committing a burglary, both entering the property as trespassers and both intending to commit theft within the property. We would convict them as principles because they've both fulfilled conduct and mens rea.
Okay.
The second type of joint enterprise is called assisting and encouraging, or aid, abet, counsel, procure. I guess you'd call it also accessorial liability. You use different words to describe it. And that's where one person commits an offence and the other one assists or encourages him to do that. The principal will satisfy the conduct and the mental element of the offence, and the assister or encourager will provide the act of assistance and encouragement, intend the act of assistance or encouragement, and have knowledge of the essential facts of the case. So knowledge of the principal's mens rea, and predict that he or believe that he would go on to cause the offence. So sometimes you've done knowing that it was going to be used in a murder, for instance. Yeah. And then there's the third type of joint enterprise, and that was what JENGBA were primarily focused when we founded in combating, and that's parasitic accessorial liability. Sounds more like an STD than
it does. Yeah.
Doctrine of common law. And that's very different. That's only been around fairly recently. Unlike the first two, been around for centuries. This type of joint enterprise came from the Privy Council decision, Hong Kong case called Chang Wing Su, 1985. And that's where two people embark on the commission of a criminal offence. That's crime A. And during the course of the criminal offence, one other person, one of the group, commits a further crime, crime B. all that participate in crime A will be convicted of crime B if they foresaw the possibility that it might happen. So they have to satisfy being a participant to crime A, either as joint principals or assisting and encouraging crime A. And if during the course of crime A, something foreseeable occurs, then they're liable for that also. And that's called parasitic accessorial liability.
Okay. It sounds very complex and sort of convoluted. Is this the right approach being taken by the criminal justice system, or is this wrong in your opinion?
So absolutely, it is wrong. It only existed for 32 years, and JENGBA campaigned for the abolition of PAL, is what we call it, because instead of intending to commit the crime or having any physical involvement necessarily in the crime, assisting or encouraging it, you were guilty on the basis of what you foresee. Now, that's why it's called parasitic, because your liability is parasitic off of your involvement in the first crime. And it was just very unfair, because the Accessorial and Abettors Act, 1861, says that those that are a participant in a crime are liable to be tried, indicted and sentenced as if they were the principal offender, stabbed the guy, pulled the trigger, caved in the skull. So you were liable to be sentenced to as if you were the one who took that life. And the sentences are very long. So since the mandatory minimum sentences, it starts at about 12 years for a youth, 15 years for an adult where it doesn't involve a weapon, and jumps all the way to 25 years if the principal stabs someone, and 30 years for if someone was shot. So these are huge sentences on the basis that you just foresaw the possibility that it will happen. You're serving the same sentence as the person that actually took that life. So that was criticised. JENGBA campaigned for 6 years, and finally we were vindicated in the case of RB Jogi, which said foresight of what might happen is not the mens rea for murder. You have to intend to assist or encourage and know that the principal had the requisite intent for the crime also. So they abolished PAL, which was excellent. And now JENGBA campaigns to have the change of the law in PAL applied retrospectively to the thousands of people convicted under the law.
Right. And there are thousands of people currently convicted under the PAL heading.
Yeah. So the Bureau, I think one of the most recent studies is a study by the Bureau of Investigative Journalists, and they did. The government don't keep statistics on how many people are convicted under PAL. They don't even keep statistics on generally joint enterprise. But what they did, the Bureau, is they did a freedom of information request, and they asked how many people were convicted during an 8-year period where they appear on the indictment for the same offence alongside at least one other person. And at least one other person was around 40-something%, like 46% of all murder convictions during that period. And 4 or more defendants under the same one, I think, was around 27%. So
quite a high number then.
Yeah, and it equated to, during the 6-year period, of like 4,000 people or thereabouts. So that's an 8-year period. PAL was applied for 32 years. So thousands of people, although they weren't all necessarily applied, convicted using the PAL construct. They could have been joint principals, and they could have been assisters and encouragers.
Right. So in terms of your brother's case, which heading did that come under? Was that under PAL in itself?
Interestingly, his is a cross between the two. So assisting and encouraging, you have to do the act of assistance and encouragement, and you have to know of the principal's intent and know that the crime will be committed, have knowledge of the essential facts or essential matters. The the phrases are different. And PAL, there's the crime A, crime B scenario. My brother was assisting and encouraging, so he believed he assisted or encouraged with his presence, actions, or words, but there was no knowledge or belief that the crime would happen. So the knowledge of the essential facts wasn't there. So he kind of fits in between. He's described as a Jogi case, but it's slightly higher than what we would see in a PAL construct.
Okay. So is the threshold to establish any one of the sort of head-ins or tenants or whatever, is the threshold high, low? I mean, the numbers you were saying of people who were convicted of joint enterprises, especially for murder, is rather high. So is it easy for the prosecution to prove stuff like this, or is it?
Absolutely. So especially when we look at PAL, you only have to prove conduct in crime A. So that could be a spontaneous fight outside a pub. And if you're saying, yeah, mate, punch him, or encouraging with your presence, because presence is allowed to be encouragement also. So if you're there emboldening your friends who are fighting with your presence, actions, or words, then for the prosecution to prove that you foresaw the possibility that serious harm might happen, it's a very small step, because anyone watching a fight can foresee the possibility that someone could get their nose broken, for example, and that is enough. You don't have to foresee the actual injury itself, unless if it's a particular weapon, you do. So if it's a particular weapon like a knife or a gun, you have to have foreseen that. But it's serious injury. It's very easy to foresee the slightest possibility of it when the crime is a violent crime. Okay,
so I've just had an example sort of come to me. What if then you're in a pub or you're in the beer garden and a fight breaks out, but you don't know either of the participants in the fight, but all you do is stand and watch. You don't actively try to break it up. Would there be any liability for an example like that?
No. So,
no.
Well, if you yelled at the group, yeah, smash him, then there would be liability. If it was a pre-arranged fight, and you bought a ticket for it, for example, RV Coney, that was a very old case, a surprise fight, you would be liable for encouraging it. But if you don't know the party, you haven't bought a ticket, then there's no evidence that you intended to assist or encourage, and therefore you wouldn't be prosecuted. The difference, so really, the distinguishing criterion between a witness and a defendant is your association with the principal.
With the party.
So do you know him? Are you friends? Is there a case to show that actually your mates, you didn't stop it, could have stopped it, didn't? Were you therefore encouraging with your presence? I get
the feeling that the vast majority of these convictions will be young men.
Because you're more likely to get involved in a fight when you're young and full of testosterone, aren't you, really? Or one of your group is more likely to fight, at least.
Okay, thank you. I read some of the accounts on the JENGBA website of excuse me, people who were in prison. And it says, JENGBA prisoner 2. Evidence against his co-defendant was that he was in a gang. However, the prosecution assumed because they knew each other, he must be in a gang too. That sounds pretty tenuous.
Yes. Sorry.
No, carry on. Go on.
So that issue with bad character is just as applicable today as it was in PAL. So where there's a trial with PAL, obviously the defendants are going to be saying, I wasn't involved in crime 1. Especially if it's spontaneous fight, there's no evidence of you're not going to, say that you were involved in crime 1 because the jump is so short to murder. And so the prosecution would often employ the gang rhetoric. And the same is equally the same today, because the law is still wrong. The mens rea is fine. That's been remedied. But the conduct element to be proven is very low. Encouragement can be in the form of voluntary presence at the scene. So I kind of use the analogy of, there's two men, they're outside a pub. and they're watching a fight. Both of them have the same relationship with the principal, and they're watching a fight. One of them thinks, yeah, he's fighting. I hope he knows I'm behind him, and I hope he knows if he loses, I'm going to jump into, and I hope he's emboldened by my presence. The other one could be there going, oh God, not again. What do I do? Do I stop it? Do I leave? I'm not really sure. And ultimately, these are the same two men. Physically, there is absolutely no distinction between their conduct, and only they know the real what their brain is thinking. They know their own, whether they intended to encourage or they didn't. So if they're the only ones that know, but both of them will end up being defendants, because that's how low it is. And it's to me, it's really a flip of a coin. And when you have, the evidential bar that low, that's when the prosecution begin to employ the gang rhetoric. That's when they use that. And there was a study by Patrick Williams and Becky Clark, Met University. And what they looked at is trials that were happening and how allegations of gang membership were used by the prosecution, and then what the prosecution uses as like a evidential basis for calling a person a gang. And what the prosecution often relied on was whether the name was linked on the gang matrix or rap videos. So with the gang matrix, they then began to look at the evidence that was required, the intelligence evidence that was required for someone to actually be on the gang matrix in the first place. They found that they didn't need to be a conviction. They didn't need to be kind of a rap video. They didn't have to be anything like that. But sometimes it would be that they were in a photo with someone else that was on the gang matrix. So then their names were added to the gang matrix. And then they looked at the race of the people on the gang matrix, and it was something like 89. I think it was 89% of people on the gang matrix were Black and other ethnic minority. That was in the Manchester gang matrix. And then they looked at the youth violence matrix, because you would assume that if someone is a member of a gang, then they would have a conviction for violence. And so they looked at the youth violence matrix, and actually it was something like 26% were Black and ethnic minority. The rest were white. So 89% Black, 11% white for the gang matrix, and 25%, 26% Black, and then 70-odd% white for the youth violence matrix. Yeah. But then that is brought into trial, and it's employed in trial for the prosecution to then say, wow, the principal was in a gang. He is associated with a gang. This is a revenge attack. And once the jury hears gang, they think violence. They are criminals. They're horrible, nasty people. I bet if one of the gang members murdered someone, they were all in it together. And that's exactly what the prosecution want and what they use, because the evidential bar is so low.
Yeah. I was reading another example where the prosecutor simply showed an Instagram account as proof of this sort of gang association. It just seems to be so low a threshold.
There was another case in Manchester, and it was 11 people were convicted of murder, and the prosecution used a rap video that had been paid for by the police. So the police gave money to a fund for youth people. It was like a local youth centre. They funded a musical kind of course for the kids to do. And one of the songs that they did was a rap video, which was then used as evidence of gang involvement, even though the police funded it.
Funded it themselves. Okay. Do you think this this sort of law or this approach to joint enterprise, with its low threshold and sort of ensnarling a number of defendants, do you think it's a sort of response to the moral panic around gangs and violent young people in England and Wales?
Absolutely. So when you look at the way joint enterprise has developed through the centuries, it always seems to be in response to something. Before the case of Coney, in the 1880 something, I'm going to go with that.
Yeah, I'm going to say 5, but I've not taught criminal law for 5 years. But yeah, you're right. 1880 something.
Something, yeah.
Yeah.
So it was a father and son. They're walking across a field, and they see a crowd gathered, and they go, "Oh, okay, let's go have a look at this crowd." And they get there, and they realise it's a boxing match. But because all the crowds hone in, they struggle with leaving. Suddenly, the police arrive, and they're all arrested, and they arrest them for assisting and encouraging the boxing match. I think ABH or common assault or something they were arrested for. And they said, well, we weren't encouraging, we weren't cheering, we weren't gambling. There's no act that you can see denoting encouragement or assistance. And but obviously that they believed that they were there intentionally to see the prize fights. So, and prize fights at the time were really bad. They were killing loads of people, were getting killed, and they really wanted to crack down on these prize fights. And one of the reasons for saying that presence, so they said, well, you don't have to have actually done anything active. Presence can be encouragement. But the reason was kind of one of causation. They said that the crowd of people actually cause the prize fight to happen because they wouldn't have attended and fought if no one had bought the tickets. So, but that was a public policy reason for lowering the standard required. And then when we see kind of the emergence of gangs or what they say are gangs, and youth violence, then they start to employ. Well, that's probably why parasitic accessorial liability came in, because although it was first applied in the Privy Council decision in Hong Kong, there's evidence of it emerging long before that, which I can't remember, but there is.
So what do you think can be done to improve this area of law in the future or moving forward? Is there a realistic kind of goal that JENGBA are looking for?
Well, in my personal view, presence is not enough. You can't be guilty of a crime for your mere presence. If the crime is premeditated, then there's been a conversation beforehand, and that would be verbal encouragement or assistance in some way. Yeah. I think physical assistance should have to be causative. So I think it should be you've lent so much assistance, like a gun or an address, that you have in fact caused the offence. You know, you're in that link of causation. And for encouragement, I think it should be literal authorization. So authorization theory, and it has to be literal. So you have to say it like an agreement, and that should be obviously evidenced. Yes. So presence not enough.
Presence not enough. Okay. Is it possible to tell us anything about the next steps in your brother's case? Is there anything going on at the moment?
Yeah. So my brother, he had an appeal, and when you're convicted under a law that's been later changed, so in your wishing to appeal out of time, so you have to usually appeal within 28 days following the date of conviction. Yeah. If you're beyond that time frame, you are out of time. And if you're appealing based on a change of the law, then you have to demonstrate what they call substantial injustice. Okay. So substantial injustice has been around for ages, applied in all change of law cases, but the interpretation has been different in every instance. In the lead up to Jogi, that changed the law, the Court of Appeal demanded that the applicants demonstrate that they were still suffering the consequences of the conviction. So they were either imprisoned, monitored in the community. One of the applicants who had been convicted by death by uninsured driving, and then there was a change in law, because before you didn't have to be at fault, and now you do have to be at fault in your driving. They appealed, and one of the successfully got an appeal out of time on the basis of a high insurance premium. So that was enough. He proved that he was still suffering the effects of the conviction, and therefore he was allowed an appeal out of time, and he was acquitted. And I would say that's a fair interpretation. And it's good because it balances the principle of finality. Law should be allowed to develop and needs to develop with the community and with what our morals are at the time should be allowed to develop. But it's not going to be, it's going to stagnate if we panic about, oh God, so many people are going to appeal and we're going to overburden the Court of Appeal if we keep changing laws too regularly. So I think showing that there's a consequence of the conviction really kind of prohibits people that have been convicted of very minor offences from being able to overburden the Court of Appeal. So I think that's a lovely balance. And that's what we thought we were going to have to pass. And in the case of R.V. Johnson, the Court of Appeal heard a bunch of test cases. I think there was 12. And they looked at what is the interpretation of substantial injustice in these particular cases. And what they said is that the applicant has to demonstrate that they would not have been convicted. So it's nothing to do with are they still suffering the consequences of the conviction. They look at the strength of evidence against the applicant. So the applicant has to demonstrate that he would not have been convicted had the law been correctly applied. Comparatively, if they were appealing within time, the Criminal Appeal Act says that he only has to prove that the conviction is unsafe, and that might not have been convicted. So you've got I might not have been convicted if the law had been correctly applied versus could not have been convicted, basically. And with the evidential bar being as low as it is and present still being evidence of encouragement, you can't prove that I would not have been convicted because the evidence remains the same. And that was actually a decision in R.V. Anwar following Jogi. They looked at whether the evidential bar, what physically needs to be demonstrated, or evidence that needs to be to demonstrate intent. You don't need any more evidence to demonstrate intent because foresight was always evidence of intent anyway. So so basically we have to prove we're innocent, and that's really unfair. So now we're appealing. Now we've got a private members bill, and we are looking to reform the Criminal Appeal Act and add a statutory mechanism for appeal. And what that does is it gets rid of the 28-day time frame if your conviction is unspent. So if you're convicting under of an offence which later reforms, and your conviction is unspent, and I thought unspent is a bit like consequences, because you have to declare that to mortgage people and insurers and jobs.
Okay. How did the private members bill sort of come around? What support do you have for that? It sounds very interesting.
Yeah, so I wrote it. I wrote it, and that was about like 18 months ago. And we had a conference at the House of Commons, and we've got a lot of MPs came. We've got quite a lot of political support for it. But COVID hit, so we weren't able to progress with it at that point. So during the course of the last year, we've had a consultation period, and we've sent the bill and a survey to legal academics. I think we sent it to about 120, and we got 15 gave us feedback, 100% in support of it. And there was a few amendments. So originally we actually went to adopt the consequences test, and we called it the ill effects test, or I did. And no one likes that. So it's too ambiguous. We don't know where the court are going to go with it, what constitutes an ill effect. Part of the survey was if it was to be defined within the amendment itself, how would you define it? And a lot of people said unspent, some people said imprisonment, and some people said societal stigma is enough even if the conviction is spent. I went with unspent because I want it to succeed, and I don't think the others will.
I think that's a good point.
I don't think anything less will succeed. They won't have it. So but it's good. We had 100% in support, a lot of MPs in support, and we're going to be working this year to get that through. I think our first plan is a mass lobby. So around October, we're going to all turn up at the House of Commons and demand to see our MPs for a mass lobby. And then we're going to use the 10-minute rule, again, for publicity, and try and get as much support as possible from Parliament and the Lords.
Okay, so how can the public and the viewers help with this then? What can they do?
So all of our material is going to be launched on the 7th of July we're actually going to have a protest outside the House of Commons, a march and a small protest, just to reunite the families. Over the course of the last year, we've not been able to meet and see each other, and we rely a lot on the emotional support we get from one another, having gone through what we've gone through.
Yeah.
So it's more of like, it's like a family day and a protest. And yeah, so that all the material is going to be launched on that day. So that would be the MP briefing packs, template letters to send to your MP, and there's going to be a petition on the Parliament website for people to sign. So that's going to start being circulated, and the actual bill itself is going to be finished because it's not finished yet.
Okay, and that's all going to be launched on the 7th, is that right?
On the 7th, yeah.
Wonderful. Okay, well, make sure you send it over, and I'll advertise it for you, as well as filling out the template letters, because something needs to change here, and you have my full support, and I wish you the very, very best of luck with it. Thank you for joining us this evening, Charlotte. That's been brilliant.
Thanks very much.
Thank you. I want to thank Charlotte for joining us this evening and giving us a very nice overview of the law surrounding joint enterprise and what JENGBA are trying to do in order to reform the law. I wish them the very best of luck with their private members bill. And if you are interested, keep your eyes peeled, because what we will do when the 7th of July comes round and the group release all their information, I will hyperlink it to the comments in this video, as well as pulling it on the Twitter feed. As ever, I'd like to thank all our supporters who help keep the show going. I'd like to thank Joe Doherty, Donna Jenkins, Lucy Green, Claire Malone, Ian Robbins, Elise Goff, Michael Saw, Pad Ryan, and Wolf Ryan. I hope you enjoyed it. I hope you learned something, and you've taken something away from this chat. So until next time,